welcome to all our members who are joining us this evening. In case you didn't know or hear that, I'm Jody Gilbo, the president of Benton Franklin Rental Owners Association, and we're so happy to have each of you join us tonight. Gary Ducalo has posted 3 new forms, and I mentioned them in the March newsletter that will be coming out in a little while. So he's taken the forms off of the WLA website, and they're actually directly off the state attorney general's website. So they're related to the payment plans for COVID. He's put them under forms that might be required on the website. So if you go through there, there's 3 forms. There's a declaration of payment plan. There's the invitation to repayment plan. And then there's a payment plan worksheet, and it gives you the opportunity to record how many times you've attempted to work with your tenant, what's been discussed. There's room to mark down, just take notes and that kind of thing. I would encourage any of you who have not yet entered into a payment plan but might need to utilize those forms, because it demonstrates that you are trying to abide by the moratorium dictates there, where you, in order to have a legal standing going forward to collect any unpaid rent debt, you have to have offered a payment plan. That doesn't mean the tenant needs to accept it, but you have to be able to prove that you have offered it. And so that worksheet would be part of that process. One other thing, the WLA newsletter, Rob Trickler put out quite a great article talking about the coalition between WLA and the Rental Housing Association. And as BROA being part of WLA, we get in kind of the back door through that. There's no charge this year to be a part of that coalition, but it gives us great access to actively participate in the legislative process. And an example of how we're working and that has been effective so far is I just got word today that capital gains tax was negotiated down from the 9% to 7%, and it exempts all real estate sales. So that is great news for anybody looking to sell their rental units here in the next little while. So, and that was as a result of this coalition. And I was listening to Kevin talk about his participation in that process. I want to encourage all of our members to be actively participating. The numbers have been fantastic. Donna Smith was talking about how on one bill alone, there was 400 people that signed up to testify, whether virtually or through written comments, and then 400 other people that just signed the bill pro or con. So the numbers are overwhelming. That participation has been fantastic, and we've just got to keep plowing through and going forward with that. So I want to remind you on March 18th. So for our next membership meeting, we will be having Megan McCormick from my screening report coming in. And there's quite a few changes to that platform, evidently. So you'll want to listen in on that. And with that, we have Rachel Woodard with us tonight. She's come in before when Powell and Gunter have been invited to speak to our group. And so she's a familiar face, but she's going to give us some tips and a little insight into what's been going on with all the legal ramifications and how to navigate that process. And so with that, Rachel, I'm going to hand the floor over to you.
Thank you so much. And thank you for inviting us to come and talk to you. It's not necessarily fun for us to talk to you during this time, but thank you for allowing us to come and talk to all of you landlords who sometimes I talk to, during my regular practice, but it's nice to get you all together. Ben Vollmer is on here just in case, I have any questions or any of you guys have any questions that I cannot answer. And also Amy Pitcher is on here, who many of you have talked to as well. So we're all probably going to field all the questions after I kind of give a little bit of a lay of the land of what I've been going through during this pandemic. And then we want to leave plenty of time for you guys to be able to ask questions of us, because I know that you guys have questions that you might want to run past one of us. So as you all probably know, the proclamation keeps on getting extended, and this last time it's extended all the way to March 31st. There's only 3 ways that we can get tenants out during this pandemic. One is a 60-day notice to sell the place as the property owner. One is a 60-day notice to move into it as the property owner. And the last one is there's a significant risk to the health and safety of others or property. As I've been navigating through this, I've taken quite a few to court on the 60-day notices to sell or to move in. The judges don't necessarily love to see me, but we have been successful. Sometimes the court has given the tenants more time, but most of the time the court has granted the writ of restitutions based on those 60-day notices. Some judges are giving me judgments for my time and costs for going to court. Other judges have not given me the cost or the attorney's fees. It just kind of depends on which judge I have or I'm in front of at that time. The significant risks to the health and safety of others has not been a fun one for me. I have only taken, oh goodness, and Ben and Amy, please correct me if I'm wrong. I think there's been 4 that we have tried to go to the court with that significant risk. My very first one, and if you've heard the story before because you've talked to me, was, I'm sorry if I'm repeating myself, but it was in June of last year, and it was a DEA drug raid out in Pasco. When I brought it in front of the judge, I lost at first blush with that DEA drug raid. I thought for sure this is what Governor Inslee had contemplated when he put that language in there. But I lost at first blush. I decided to ask the judge for a motion of reconsideration, added some additional information that I didn't have the first time going to see that judge, and was eventually successful getting that tenant out of there. So when we look at significant risk to the health and safety of others, you can see that the court wants to see a pretty significant issue. And I thought I had one, and I guess, yes, I did have one, but not enough for the judge on the first time around to persuade him to utilize that significant risk. I've had landlords call me and say there's junk outside. They don't throw away their garbage. There's no electricity. Can I use significant risk? And most of the time I'm telling them no, because of my experiences with the very few that I've taken and the judge's hesitation on using that that issue to remove the tenants. So with that, the other ones that I took, one was a man that was, my goodness, he was arrested for child pornography, and the court didn't have to decide that one because the tenant was willing to move. I had another one where the man was arrested for murder, and once again, did not have to take that all the way through. The last one I was working on was with an RV park where a tenant was removing her sewer line and dumping raw sewage. We never fully have figured that one out because Northwest Justice got on the other side and complained about different issues in that case. So I haven't taken very many, but you can understand what kind of gravity I think that the court is wanting to see before we go forward with using that last prong. So we've been pretty successful on those 60 days. Like I've told you, we've, been to court. I've had a judge that has argued with me on some of those 60 days, saying that they believe that the landlord is just using a loophole and just wanting the tenant out. But even that judge at the end of the day, after arguing with me, gave me my 60-day notices. So here we are plugging along with 60-day notices. And then I get a call. Well, actually, I was calling one of the attorneys over on the west side of the state about a different case. And they tell me about a case out of King County that is called Nyman versus Hanley. And Nyman versus Hanley is going to be taken up to the Washington Supreme Court and heard this spring, hopefully. But it puts a wrench in those wonderful 60-day notices that we have been pretty successful with going to court with. Nyman versus Hanley is a case where before the pandemic started, the plaintiff, the landlord, sent a 14-day notice to pay or quit. By the time they got to court, it was too late. The pandemic had started. So once the governor allowed the 60-day notices, the landlord then served a 60-day notice that the landlord was going to sell the property. Not Northwest Justice, but I believe King County Housing Project came and represented the tenant in this case and stated that the CDC has its own moratorium on evictions, and that is more restrictive than Washington's. Therefore, this landlord cannot use a 60-day notice for this tenant. If you guys are familiar at all with the CDC's moratorium on evictions, you will know that there's a certain criteria that the tenant has to follow in order to be a covered person under the CDC. So if this tenant files a declaration and states that they comply with I think there's 5 requirements, they are a covered person under the CDC. And the CDC will not let you evict unless there's some sort of tenant misconduct. Well, in this case, it's a 60-day notice for the tenant to move out because the landlord's selling it. So the King County Housing Project is arguing that CDC has to be followed and therefore they cannot be evicted. This tenant cannot be evicted. Well, at the trial level, the landlord won, but they took it, the housing project appealed to Washington State Supreme Court, and we have yet to figure out that ruling because I don't think they're going to hear it until the spring. So now here we've been somewhat successful with these 60-day notices, and it could be very well not something we could use anymore if the Supreme Court of Washington decides that the CDC is applicable here and we need to follow the CDC rules rather than Governor Inslee's moratorium on evictions. So the CDC says that if a state has an equal to or greater restriction on the moratoriums, we don't have to follow the CDC's guidelines on evictions. Well, the landlord took the argument that Washington does have an equal to or greater moratorium on evictions. Therefore, we don't have to follow the CDC. And that's the argument there. Whether or not the CDC controls in Washington or whether Governor Inslee's moratorium on evictions governs in Washington. So it's frustrating for us who have been somewhat successful and really kind of helping the judges understand the moratorium from Governor Inslee and helping them understand that we can go forward. We've gotten to a point that they've seen me enough, they know why I'm there, and getting these tenants out and being successful. Now there's a wrench kind of thrown into it. A couple of things, at least we are obviously still going forward with 60-day notices because that Washington Supreme Court case has yet to even be docketed as a date to be heard. So we're simply going forward with 60-day notices under Governor Inslee's proclamation and utilizing those until we hear something different. A couple of things on those 60-day notices, if you're not doing, we have seen where some of our landlords have not ended them at the end of a month. So let's say it's the 15th of January. Well, they ended on the 15th of March. Well, after a couple of the revisions or the extensions of this moratorium, they have added language in there that the Attorney General's office is reading into that we have to end those 60-day notices at the end of a month. So if you are like today, which is the 18th, and want to serve a 60-day notice, you're not going to be putting an end date until April 30th versus April 18th, even though February doesn't have 30 days. So we'd probably be even farther into April. But those are issues that we're having. We're also, or issues that we're seeing. We're also seeing landlords make their own 60-day notice that maybe doesn't have the language in there. We have, as far as the moratorium, we have not seen an issue with that as far as making your own, but just make sure that you put on there if you intend to sell or if you intend to move in. Other than that, I'm trying to think of any other issues, Ben or Amy, any other issues that I need to bring up to these landlords about those notices?
Yeah, just one that comes to mind is it needs to be in a declaration, sorry, an affidavit format. So we've seen some that have come in that have not been under penalty of perjury, have not been notarized. And so that's something that it needs to be. It also needs to include language that the notice is not just a 60-day notice under the proclamation, but that it's also a 20-day notice terminating tenancy under RCW 5912. So it's kind of that's why it has to end at the end of a rental period, usually the end of the month, like Rachel said. So I think that PROA has the 60-day form available to you guys, and I think it satisfies all of that stuff. So if you use the form that you have, you should be fine. But we have seen some people that have just kind of done their own form, or they've pulled forms on from the internet, or they've pulled forms from the internet that were valid during the first or second version or phase of the moratorium, but are no longer valid because the moratorium's changed and the governor's added additional restrictions or requirements to the notices, such as the requirement that it be under penalty of perjury and be an affidavit. So yeah, those are I would say almost, I don't know, Rachel, you can correct me if I'm wrong, but probably a third of the notices that we get that come into our offices are invalid for some reason or another. They don't have some of the required stuff that needs to be in the notice. So that's isn't this just fun? It's all very, very fun to deal with this stuff. I mean, it's already technical enough, and then adding all these additional restrictions has just really made it difficult for landlords to get that right. And also, of course, the normal service requirements that are required for any service of a notice also apply to the 60-day notice. So it needs to be either posted, mailed, or hand delivered, and all the usual precautions and requirements that you would do with any other notice, you should do with the 60-day notice as well. So.
Thank you, Ben. Amy, did I miss anything on those 60 days?
No, I think that everything was covered. Just to emphasize what Ben said. If you, it's terrible if you serve a 60-day notice, wait 60 days, and then you turn it into us and we say, yeah, this doesn't work. So I'm happy to review notices that have been prepared. If you want to email them to me and I can look them over and say, yeah, this is good. No, this isn't good, before you spend 2 months waiting.
Thank you. The other thing that we get a lot of questions about is there's a paragraph in the proclamation talking about repayment plans. And it talks about how if you offer them a repayment plan, it seems to allude to the fact that you can go forward with an unlawful detainer. Ben has dealt with the Attorney General's office on this issue, but our office and the Attorney General's office takes the position that you can't move forward on an unlawful detainer if they fail a payment plan, if they refuse a payment plan. We believe that it'll be used for whatever's next to come from the governor's office. If he finally lifts this moratorium, not that I have any inside information, but if he lifts the moratorium, most likely there'll probably be some sort of repayment plan forced upon landlords to utilize the back payment of rent that so many tenants are so far behind on. And so I'm assuming that this paragraph is leading to those types of issues that the governor is probably contemplating after he lifts this moratorium. And so Ben has obviously talked to the AG's office, and we definitely take the position that absolutely you can ask them for a payment plan, and if they choose not to make a payment or choose not to even make a payment plan, that doesn't mean you call us up and say, okay, I want to evict them now because I tried to give them one, or I gave them one and they've already failed. We think that the Attorney General's office would quickly come to the defense of the tenant, and not be a very cheap process for our landlords who decide to take that to court. So I want to leave plenty of time for questions. Anything or anything else that you guys want me to cover. Obviously we get a lot of questions about breaches in the lease. There's too many tenants in there. There's people that are not even on the lease that are in there. They have pets, and we don't allow pets. They're doing this or that. There's really no way for us to get them out during this pandemic outside of those three issues that or those three ways that the governor's office gave us. We always tell people that if they're in danger, if there's harassment or anything like that, you have to call the police. But really there's not a lot that landlords can do when there's a breach of the lease on those type of issues during this time. So I am ready to take questions unless Ben has anything else on this.
Okay, Rachel, so looking down through the chat box, I see first question from Steve. What are the 5 CDC criteria?
Yes, so the CDC will only apply if the tenant signs a declaration under penalty of perjury that the individual has used the best efforts to obtain all available government assistance. Let me quantify this before we start going through this list. So let's say you find that the tenant has not done one of these things, or it's not applicable to the tenant. They're basically saying, the CDC is basically saying, you can't as a landlord use that as defense in your unlawful detainer. You basically have to sue them for perjuring themselves, and then come back and utilize that perjury to help with your unlawful detainer. So you can't use it in your unlawful detainer as, no, they didn't do this or that. You have to come back around after you've proven in court that they basically lied under oath, and then come back to the unlawful detainer. It makes it really friendly for the tenant. So the first one is the individual has used the best efforts to obtain all available government assistance for rent or housing. The individual, number 2, the individual either expects to earn no more than $99,000 in annual income for the calendar year 2021, or no more than $198,000 if filing a joint tax return, or was not required to report any income in 2020, or received an economic impact payment stimulus check pursuant to Section 2101 of the CARES Act. Number 3, the individual is unable to pay the full rent or make a full housing payment due to substantial loss of household income, loss of hours of work or wages, layoff, extra or out-of-pocket medical expenses. Number 4, the individual is using best efforts to make timely partial payments that are as close to the full payment as the individual circumstances may permit. And number 5, eviction would likely render the individual homeless or force the individual to move in and live in close quarters or in a shared living setting. Those are the 5, and they're ands.
Yeah, okay. So yeah, they have to make all 5 of them. So okay, does that answer your question, Steve? The next question, if a tenant fails to make payments on a payment plan, can they be taken to small claims now? I think you answered that, but I'll let you do that again.
I believe that they can't. I think in the proclamation, it talks about collecting, and I know that paragraph is not a fun one because I read it like many of our landlords read it, that once we ask for that payment plan, can we go to, and they fail, can we go to small claims court? I have not had a landlord try it, but I'm not advising them to do it either.
Okay.
Just to follow up on that. I called and asked the Attorney General's office that question because that's kind of what the proclamation says, right? So, why can't we do what the proclamation says? But they read it as, at least the person I spoke with, one of the attorneys that read it differently and said that, well, that all the generally does is allow the landlord someday when the moratorium is lifted to go after the tenant for unpaid rent, whatever that means. So, and I don't know when that is, and I don't know what that looks like, right? We don't know, when this is ever going to be lifted, and when it is lifted, how it's going to be lifted. My hunch is it's probably not just going to be lifted altogether at once. It will be with restrictions and stuff. So, anyway, it's not really that helpful. So.
Thank you. That's kind of how I've been reading it too. It's just it's kind of like a promissory note at some point in the future. So, okay, next question from Reagan. What constitutes verification of having offered a repayment plan?
Good question. We don't get a lot of guidance when we call. So Governor Inslee is the one that wrote this into law, and then the Attorney General's office is the one that's policing it. So Ben and I have talked to the Attorney General's office more than we'd probably admit to how many times we've called them. And we don't get a lot of direction on that. I know that before Jody was saying there's certain forms that, you might be able to use that they have shared with you. I think anything that you can get in written documentation, which is somewhat hard sometimes when tenants are not willing to cooperate, but anything written down as a payment plan that you've tried to work through, I would say would be valid, but we have not gotten any direction whatsoever from the Attorney General's office on that.
When people call our tenant landlord line, there's a proper way to serve notices. Of course, in-person service is always the preferred method. However, since we're required to provide proof that we've offered this plan, I've been advising people to go ahead and post and mail and get that certificate of mailing as the best way at this point to try to prove that we've done that. So
I think that's a wise thing. The problem is you need to know what the tenant can pay, right? And to make it a reasonable plan, you need that communication door open. And many times when they're not paying their rent, the last thing they want to do is sit down with you and tell them if they're getting unemployment, if they have a job. And so to make a reasonable repayment plan, it's hard when you don't have that communication line. But Jody, I agree with you. At least you're trying something. And I think that's all you can do without getting any additional direction from anyone within the state to tell us what that means.
true, because it's more than anything an invitation to open a dialogue to try to go forward. So
absolutely.
That it's, I don't think any case law or any court has published any opinion that describes what is reasonable. And, for a payment plan, it talks about, the repayment plan has to be reasonable based on the individual financial health and other circumstances of that resident. Well, it's really hard for a landlord to know that. And so, what is reasonable to one tenant may not be reasonable to another tenant. And I think that's going to be difficult for a landlord. You could just see that sort of issue being litigated as to whether or not something, a particular payment plan was reasonable for that particular tenant. It's just not well drafted. Like everything else, it's not very landlord friendly.
true. Okay, so next question from Gary. After the moratorium is over, will there be a method of eviction for non-payment of rent? Do you have a crystal ball?
I just had a landlord call me today and said, I know this is an unfair question, but where do you see this in 24 months? I just started laughing. I think based on, and this is just my opinion, based on what the governor has done so far, and that he's so worried about homelessness, right? He mentions it every single time he extends these proclamations, that I think he'll do some sort of repayment plan. It just seems like here he did all this work to keep them in there for so long, and I doubt he's going to open up the floodgates. I just can't see him doing that when he's so focused on keeping these tenants in a house or in, having a roof over their head. I just can't see the man just going, okay, well, it's expired now. Have fun, tenants. You need to pay all your back rent. I just can't see him doing that.
My hunch is that when they do lift it, and again, I don't have, my hunch is that when they lift it, they're going to put some sort of restriction on landlords being able to go after tenants for rent. They may just forgive all rents during the COVID period. And they may, they've talked about, there's been different bills for like a landlord relief fund that they'll set aside some money in a fund that will be for the benefit of landlords, that landlords can go and apply to get money for unpaid rents, and at least a percentage of what they're owed. But I think at this point we don't have any of that in place, and I don't know that there's any money in the state to fund something like that. So, but I agree with Rachel. I think it's unlikely that the governor is just going to lift it and let landlords, evict all these tenants that haven't paid rent. I mean, the ones, I think a lot of landlords have been hit in different ways, but we have some clients who are property management companies that, manage lots of properties, and some properties, even around here, are, there's 20-30% of tenants that aren't paying rent. And some of them have been affected by COVID, had COVID or lost their jobs, which I think is what the proclamation is intended to cover. But then there's a lot of tenants that just take advantage. They know that the moratorium's there, and so they take advantage. But there's quite a few even in our area here that are not paying rent. So if the moratorium was just lifted, today, there would be massive amounts of evictions going on. I think. I mean, we usually do somewhere around 20 to 30 evictions a month. Right now, we're doing less than that, maybe I don't know, 3 or 4 a month or so. But it would be chaos if the moratorium's just lifted and the floodgates are open. I think so. I don't think that's going to happen.
Unfortunately, I agree with you. So, I mean, at the best offering I've seen, they're offering money if the landlord accepts it, but it's only up to 80%. And it's like, well, why should you have to eat the other 20%? But those restrictions, yes, I don't see them going away. So the next question is, if a tenant is behind on rent and there has been no discussion or a request for repayment, will it be acceptable to offer the anticipated government plan after the moratorium?
I don't understand the government plan. What does that mean?
Roger and Dana, can you guys clarify that? Perhaps unmute yourself so you can pose your question directly.
Yes. So I guess what I thought I heard said was that at the end of the moratorium, there's probably going to be a ruling by the government that we must have to follow a certain way of collecting on back rents or following an eviction process. So if we've been kind of kind to our renters and said, let's just do what you can do right now, and we'll deal with this more when things improve, then is that acceptable? Or do we have to offer this repayment plan before we'd be eligible to follow the new plan that might come about after the moratorium is over?
I see what you're saying. So it does allude to offering a repayment plan in the proclamation, and are you saying, do I have to offer that now during this time for the next step, whatever the governor does, to allow me to utilize that? And I really don't know that answer, because I don't know what the governor's next steps would be. I don't think it, I mean, hurts you to offer that, but I don't know if it helps you to offer that either, because I really don't know what the governor's next step will be, as far as a foreshadowing of, you know, that he would require you to do a repayment before you can take his next steps. I just don't know.
Thank you.
Okay, so the next question, how and where can landlords now apply directly for rent support? I don't know if you have an answer to that, Rachel or Ben.
I do not. I might, some of the other landlords might know.
I just got off the phone with Nicholas Yuva yesterday.
Okay.
And regarding this whole thing. And according to Nicholas, currently right now, we may not, there's no way for us right now currently to apply on behalf of tenants for rental assistance. However, there's ERAP, there's TRAP, there's certain things coming down. It is coming down the pipe. It's going to happen. In the chat, I put in there the Benton Franklin Coordinated Entry System. That's the phone number. That is the point of contact in Benton County where you're going to contact for if this is going to happen. Also on this webpage, the CAC, which is Community Action Committee, they are also another point of contact where you will be able to access this. I would highly recommend, if you do not currently have a state vendor ID, that you get a state vendor ID, because you're probably going to need it and it takes time to get it. And I would also recommend that you are calling pretty much on a daily basis, because when it opens up, the floodgates are going to open, but there's only going to be so much funding. And so you're going to have to be on it, because it's probably going to happen very quick. And funds are going to probably disappear very fast. The other thing about this is I just got a little over $3,000 in rent approved that's being paid in back rent from CAC. I will tell you, it has been an uphill battle. It has been a climb. I have basically had to hold the residents' hands through certain things. I had to walk through things and they didn't even know about it. I had to go personally get educated about it and then walk them through it. But we did manage to finally get through it. And there are some programs out there. And so the CAC, and I'll put that phone number in the chat here real quick. Along with the Benton and Franklin Coordinated Entry System. But those are going to be your two entry points on trying to get rental assistance for those residents.
And I addressed that in the March newsletter that will be coming out. There's a couple different websites there. Other options are St. Vincent de Paul is a nationwide charity, and lots of groups work with that. So you can always call. There's a St. Vincent de Paul in the Tri-Cities, Kennewick. Salvation Army, obviously. Try calling your Chamber of Commerce. They're kind of the central point, and they contract with lots of different other organizations. According to Donna Smith, who is the WLA delegate, these programs, there's funds, and then when they're exhausted, they shut down. But when they're replenished with more funds, then they're open again for more applications. So you just have to keep going back, having your tenant keep going back and reapplying, because it's not a one-time thing. And like Kevin said, sometimes you're going to have to walk your tenant through that process, but come across to your resident that you're trying to do everything you can to help them, not that you just want your rent. So you're trying to help them stay solvent. That's what you're trying to do. And that might get a few more of them to try to apply. So approach it in a friendly way, as opposed to a us versus them adversarial attitude. So
that's correct. And somebody asked about CAC. Yes, the Community Action Council, they have different programs depending on age, depending on family, depending on different situations going on. So it's worth a phone call to them, tell them what's going on and get information, and then relay that to your resident or your tenant, sorry. And then try to help them navigate the system, which is what I did. But do understand they are fielding a bunch of calls. And so once you find a contact with somebody there, I would highly suggest you stay with that contact, because it's an interesting journey. Let's put it that way.
thank you, Kevin. Okay, next question. If a tenant is getting housing assistance but failing to pay rent, what are my options? So this is from Martin. I'm assuming you have a subsidized tenant and you're talking about their portion of rent that they're responsible for. Is that correct? Martin, do you want to unmute yourself? Okay.
Think I don't have a speaker unless you can hear me.
We can hear you.
So, okay. So basically, the tenant, I believe, is getting assistance, but I'm not getting the money directly. So I think it's going straight to the tenant.
And that
Do you
may
know
be,
where-
yeah.
Do you know where they're getting the assistance from?
I assumed it would be through the housing authority, but I'm not sure. I believe it's through, I don't know, a government program, but I have no idea which one.
Is your tenant a Section 8 tenant or some kind of voucher program like that?
Very limited income. I believe they're getting as much assistance as they possibly can, but it's a bad situation. Haven't paid rent for 16 months.
Sure, I
And,
understand that,
so-
but did you sign a contract with the tenant through a Section 8 or other voucher program? Because what I would recommend that if that's the case, that you go and speak to that case, whoever is handling that case. If it's the housing authority, go and speak with a caseworker there. Because if I understand that program directly, at least the subsidized portion is paid directly to you, but somebody else who's dealt with Section 8 or another housing voucher.
Jody,
Yeah, go ahead.
if you were dealing with Section 8, you would have a contract signed with the Kennewick Housing Authority, and their portion, the portion that Section 8 or the housing authority was paying would come directly to you. You'd have to fill out a W-9 and all of that. And that's true with CAC and the community action. I know that because I just did one, and you have to sign it and you have to fill out W-9s and everything, and the checks come directly to you, the landlord. In there. Now, then, if they're receiving assistance from like a church or something like that, that's a different story. But a lot of times they're going to be contacting you directly and sending that check to you directly. It's not going to go to the resident. So I would be questioning that one with the resident a little bit, because normally those checks would be coming directly to you.
I agree with that too, Kevin. I think that's what we usually see, even with churches and other third parties. Usually it's they pay it directly to the landlord just for that reason, right? The tenant may or may not.
That's correct. And usually you've got to fill out some kind of tax documentation for them as well.
Right.
And so if you're not
Okay.
receiving your rent, then unfortunately you're in the same boat as many other landlords. And so you offer the payment plan and you're kind of stuck until Governor Inslee decides what he's going to do. So.
Okay, so they won't meet the door, open the door. I've requested 3 or 4 times an inspection of the property. They ignore that. So there's no discussion. So yeah, that's not possible.
You can still serve the notice, post it on their door and mail it to them, offering a payment plan. That's what we were just discussing about having that proof, get that certificate of mailing and serve that notice in the legal fashion, and abide by all the rules necessary to do that. And like I said, they don't have to accept it, but at least you have proof that you have offered it. So it's at some point you may be able to pursue that collection of that.
I think Martin's expressing the frustration that we hear on almost, I think we probably get on average 2 to 3 phone calls a day. In that boat, they have tenants who are not paying rent and won't talk about it. They may be in violation of their lease in many other ways. and there's really nothing we can do about it. It's just frustration, but unless you fall under one of those three categories that Rachel mentioned, you're sort of stuck. Unless the Supreme Court decides that the proclamation is invalid because of the CDC, then you have to fall into the CDC, then we're stuck under a different framework, which is, probably actually more landlord friendly because it allows for eviction based on non-payment of rent.
Hey, Rachel,
Okay,
sorry, go ahead, Martin.
Question. Okay, I served them a 60-day notice. They were supposed to be out the end of December 31st. They're still in. So now I go to an eviction notice. Is that what I have to do?
You would actually start a lawsuit now based on that 60-day notice because they did not move. That is correct. Yes, you do a summons and complaint.
Okay, so I have to get a hold of a law. I can't do this myself. I have to go through an attorney to do this then.
And Rachel and Ben are right there. I would
You
contact them.
You can actually do it yourself. You do not need us. Obviously, if you haven't done it before, it is a little bit daunting, but you do not need an attorney to do it.
There's no.
Well, no, I'm willing to use an attorney. I'm just asking the question. That's not a problem. Yeah.
There's no
All right,
legal
thank you.
requirement there's no legal requirement to use an attorney. And certainly, I'm not saying this to drum up legal services. Heaven knows we are busy enough as it is, but it is a fairly complicated process to go through if you haven't done it before.
And Martin, I understand not
All
wanting
right,
to
thank
spend
you.
any more money when you're hurting for money, but I would also recommend that Rachel and Ben are familiar faces in the courts. The judges recognize them and know them, as opposed to you walking in and trying to do it. I just think it puts you at one more disadvantage. So obviously it's a business choice that you have to make, but sometimes you have to spend the money. So.
And just one other thought on that. Before you pay us money, to do an eviction, we have had landlords successfully negotiate with their tenants to pay them to leave, the old cash for keys trick.
Mm-hmm.
That I always tell landlords that, you're better off paying the tenant to leave than you are paying us, right? So certainly don't give them any money until they're actually gone, but that's not a bad plan. So anyway.
Thank you. Okay, so the next question from, excuse me, did you have any more comments, Martin?
No, I'll be getting in touch with you guys. Thank you.
Okay, so from Dawn, if we do a payment plan and they get further behind, do we have to continue making a new payment plan?
You don't. I mean, it's obviously trying to get money out of your tenant, right? But if that leads to more money from the tenant to do an additional payment plan, money is better than no money, but you do not have to keep reinventing the wheel with the payment plans. The only suggestion would be is if you do keep redoing the payment plan, you might be getting money versus not doing anything at all, but you do not have to.
Okay, thank you. If anybody wants to see that phone number for the Benton Franklin Coordinated Entry System, Kevin has listed it there. Also in March's newsletter, I've included the link to the Office of Financial Management. That is where you go to get your state vendor ID, and it's currently taking about 10 to 15 days to process those applications. So if at some point you want to be proactive and try to get that before you would need to apply for any federal funds, I would recommend that you do that. It's free of charge for you to apply for it and get that. And you don't have to ever use it, but at least you will have it. Two other points of rental assistance that will be listed in the March newsletter is Goodwill Industries. There's a number for Hilda Munoz for dealing with that, accessing that, as well as Benton Franklin housing, well, it's in the March newsletter. There was 2 other sites that were included off of the governor's website for rental assistance. So be looking for that in March. Okay, again from Martin, maybe this is just a continuation. Can the state be held culpable for lost rents due to their involvement in our normal business practices? And if so, will the association sue the state on our behalf, such as a class action suit? They're kind of already doing that, I believe, but I'll let Rachel speak to that.
I have only heard from Mr. Trickler on that. And when I had spoke to him, oh goodness, was it 2 weeks ago? He wasn't able to give me any updates on that lawsuit because he and I spent the majority of our time talking about the CDC versus Governor Inslee's moratorium and that Washington Supreme Court case. So I don't have necessarily any updates unless someone else does. I have not heard anything new about that case.
Okay. And that might be what WLA is also currently, as we are having our Zoom meeting, having theirs. And I think some of that is addressing that lawsuit. So I'm hoping we had somebody that was able to listen in on that, or try to see if WLA has recorded that and archived that for viewing later. Reagan asked, what is CAC? That's the Community Action Center. And Kevin has once again listed the phone numbers for that in the chat box if you'd like to take a look at that. Or Community Action Council, excuse me. Also from Reagan, if a tenant is receiving CARES support, what accountability is there that they use rent support for unpaid rent?
Well, that's the $1 million question, isn't it? There's no accountability, and that's what's so frustrating about this with landlords is many of you have called and said they get unemployment or they haven't lost their job at all and they're just not paying their rent. There really isn't any accountability. And quite frankly, one time on the phone with the Attorney General's office, when I was somewhat annoyed, I asked who's policing the tenants. Well, as you probably already know, that didn't go over well because I don't think they are policing the tenants. And so there is no accountability that I know of.
Okay. And okay, so Donna and Gary, they've said they have received 5 months rent from Benton County Human Services. That was the other place I was talking about. They've listed the phone number there, 509-783-5284 in Kennewick. So keep applying and applying and applying, or having your residents do until we can apply directly. Okay, so where do we apply for a state vendor ID? If you simply did, I've included links, but they're too long right now. They'll be in the March newsletter.
Jody,
Yes,
there's a
go
link.
ahead.
I just put it in the chat.
Oh, you did right there. Okay.
I just put a link directly to it, and somebody asked, what can the state vendor ID be used for? Also, if you're going into the landlord mitigation fund, it could be used there. I'm using it right now in the landlord mitigation fund because there were damages that were beyond what the resident paid. So we're going to get the damages from the landlord mitigation fund as well. So that's what else it can be used for.
And they're processing those claims right now?
Yes, I talked to Nicholas Yuva yesterday.
Okay, well, that's great. I know that some of them regarding the unpaid rent are not processing through right now, right? Because that has to go through the court in order to qualify for that.
The unpaid rent, correct. Not unpaid rent. We're talking about
just damages.
We're talking about damages. And yeah, the only way you can do that is if they receive some kind of assistance, like from CAC, from Housing Authority. They had to receive some kind of state assistance.
Okay.
In order for you to utilize the landlord mitigation fund.
Okay.
Paul says I put the wrong link.
Wrong link.
Well.
Oh yeah, it's music theory. Okay.
Oh, sorry. Who wants to? If you want to know music theory, let me know. I can do that. I'm putting the right link in right now. I apologize for that. So please don't click on that link. Try that link right there, folks. There you go.
Okay, so yeah, there you go. Office of Financial Management. So it looks like it's a pretty straightforward application. I looked at it the other day, and like I said, it's free to apply. It does take a little bit of time, so try to be proactive and get on there just in case you're able to or need to. So are there any other questions?
Jody, I have one question. Sorry for them real quick. When we're dealing with people that are in violation of their leases for various reasons, whatever it is that's happening, would you agree or disagree that it would be best practice to at least issue a lease violation in the form of a letter, making sure that it's not threatening any type of eviction, but just notifying them that they're in violation of the lease and that they need to, like in the language from the lease, and that they need to comply with the lease, and here's how they comply with it, and you deliver that letter and document it. So you have documentation that they've been in violation, at least they've been asked to comply with their lease agreement. So at some point when this moratorium lifts, you've got documentation throughout time, and hopefully they'll comply with the lease agreement, they'll correct the lease violation, but you've at least got documentation and a paper trail leading up that you've been asking them to comply with the lease.
I think that does, it does help you, but it doesn't solve the issue of when this does, lift, that you would have to once again serve an actual notice if they are breaching again or whatever they're doing. You can't go back and say 5 months ago they were doing this, and I want to give a notice now that it's lifted. If they've rectified it, you're going to have to wait again for them to violate the lease. Simply give the notice after this is all done.
Correct. But assuming that they haven't corrected the lease violations, you've been going up to that. And it finally comes down to where you can finally serve a 10-day to comply legal notice, but you've got documentation that you didn't just all of a sudden serve it. You've been asking it all along the way, and they never complied.
Absolutely. Absolutely.
Okay.
It only helps you to pepper your file with that.
Okay.
I would just add to that, just make sure not to put any sort of threatening language in
Correct.
there. There's, prohibited from serving or enforcing or threatening to serve or enforce any notice requiring a resident to vacate any dwelling or part. So make sure it's not a notice of eviction, right? It's just a, hey, you're not supposed to be smoking, or you're not supposed to have that Rottweiler, whatever it is. That's a violation of the lease. Just if you could stop that. I mean, there's really no teeth to it, right? But I agree. I don't think it hurts. I think it's
You're right that there's no teeth to it. However, I've changed like all my screening questions that not asked only if they have any legal notices, but have they received any written lease violations? Because right now you can't serve legal notices, but you can serve written lease violations just as long as you don't threaten eviction. So you could have those documented. So I changed all my screening questions, and I also changed my screening questions to ask if they were not only do they have any outstanding rent, but were they negotiated in any way to leave the property?
Oh,
that's one of the screening questions I now have on there. Like I said, it's a chess match. You play the game, and you start figuring out how to ask certain questions the correct way to get the information you need.
So, Rachel and Ben, we know that retaliatory actions are obviously illegal, and rightfully so. So if we've done these notices of violation and then somewhere in the future the moratorium is lifted, are all of a sudden the slew of evictions and notices and all of that, will that be considered retaliatory?
Well, in order for them to use the retaliation statute, and Ben, please correct me if I'm wrong, because we haven't been in the regular statute in so long that I think I'm kind of, I need some brush up on it, but I believe they have to be current in their rent. Is that correct, Ben, in order for them to use that statute?
Yeah, I think so. I think that's a pretty narrow, the retaliation statute is pretty narrow in what it applies to, and usually it doesn't apply. I don't think so. I think you'd be fine.
Okay.
Ben, and then our judges here in this area, the first thing you say is, first thing they're going to ask is, are you current in your rent? And then they're going to say no, and then the judge isn't going to hear anything else. He's like, okay, I'm done. Just first you have to pay rent. So, and I've seen that firsthand when someone tried to do, like, say, oh, I'm filing a restraining order against my landlord, and they wouldn't even hear that because there was a rent issue first.
That's exactly.
Okay. Okay, are there any other questions then? Okay, I don't see them. Well, thank you very much for joining us this evening. Again, I want to encourage all of our members to make sure to join us March 18th at the same time. for an update on myscreeningreport.com. So
I guess I had a question. This is
okay,
Evan.
go ahead. Yep.
So to Kevin's point, so you went through and added questions on your tenant screening document. So do you have any outstanding rent, and so forth? The previous landlord, potentially would want to get rid of them if that was the case. What would you suggest for verification of those kinds of questions that a background check may or may not reveal?
Verification of questions, like what do you mean, Evan?
So you asked, do you have any like back rent that's owed or something along those lines? And say the previous landlord is super excited to get rid of them. And he's going to say, yep, they're all paid up.
Well, so here you go. Here's the deal, because I have done this. I have negotiated out a resident. I just did it 3 months ago, where we forgave any back rent they owed and even returned their damage deposit just to get them out the door. And they took it. So if somebody asked me, do they have any outstanding debt? The answer is no. However, if you ask me, were they negotiated out for any reason? The answer would be yes. That's why I switched that question up in the screening to ask that question, because I personally have negotiated somebody out of a unit, and so I didn't just leave it for back rent owed. To answer your question probably a little bit more truthfully, or to dig deeper, you got to make sure you're asking the right questions. I finally had a landlord ask me, did they threaten any legal action against me, because they were asking me questions, and I finally said yes, and they finally started asking the right questions, because they wanted me just to tell them about the resident. So my biggest thing would be is, if you are screening, first of all, I would say use a screening agency. Two, I would say use a screening agency that you could work with, that you can get the right questions asked that you want asked. Like the screening agency I work with, I set the extra questions. And third, there are no guarantees. You're not going to hit 100%, but all you can do is try to mitigate your percentages.
And in fact, Evan, some of the legislation coming down is prohibiting background check companies from disseminating information as a result of unpaid rent and debt associated to the COVID period. So yeah, you'll have to be just a little bit more savvy, like Kevin says, and but make sure your questions are yes and no answers.
Yes.
Do not ask for things that could be subjective or something like that. And same applies to you as a landlord. If someone calls you, make sure that you do not let your personal opinion color your answers, because you may put yourself in legal jeopardy. And so make sure you answer honestly, yes and no. So.
Correct. Yeah. If you call us up and you ask for us, what do you think about a resident? Can you tell us about them? Don't be put off if I tell you ask the questions and I'll answer them. And I want you to ask close-ended questions, yes or no questions, just to protect ourselves from interjecting any bias into it. So.
Okay. Any other questions or comments for anyone? Okay. Well, thank you very much to our guest speakers. A wealth of information, not necessarily good news, but there is hopefully avenues that we can utilize going forward. So hang in there, you guys, and we'll meet again next month. Thank you, and y'all have a good evening.